I will talk to you about a more invisible threat for journalism, the threat resulting from the moderation of journalistic content by online platforms. So first of all, I'll ask the question whether online platforms should moderate any user's content online, and then I will move on to asking whether they should also moderate journalistic content. So whether we like it or not, online platforms moderate users' content day in, day out. It's the bread and butter of their operation. They do it partly out of a sense of corporate social responsibility and partly on economic grounds to create an attractive environment for their users. And as stated by Gillespie, moderation is the essence of platforms. It is the commodity they offer. It is their central value proposition. And moderation happens both by way of human moderators, but also by way of algorithms. Now, moderation by platforms has been controversial in certain instances in the past, and one of these instances was the trending news controversy in 2016, where Facebook was accused of having an anti-conservative bias. And in order to contain this scandal and the revelations actually by a former employee that it was treating conservative views in a detrimental way, Facebook moved on to dismiss its human moderators. However, this led to an influx of disinformation and hate speech on the platform, as a result of which Facebook then moved on to altogether abolish the trending news feature. However, the question of whether online platforms are biased against certain views has remained in the public debate and has recently motivated the legislators in 2 US states, in Texas and in Florida, to pass laws, to propose laws, so-called anti-online censorship laws that would prevent online platforms from censoring views online and from moderating content. In Texas, the Fifth Circuit considered the Texas HB 20 law and found that it was constitutional, that it complied with the First Amendment. However, the 11th Circuit in Florida declared Florida's Senate Bill 7072 as unconstitutional and as a breach of free speech protections under the First Amendment. Why did these courts reach these contradictory judgments? Part of the reason is that they use different analogies. So the Fifth Circuit compared online platforms to common carriers. It argued that Facebook and YouTube and Twitter are similar to telecommunications operators who are subject to non-discrimination obligations, and that they therefore would not be allowed to discriminate against certain views and to favor others. It subjected the Texas law to a so-called intermediary scrutiny, to a kind of lower level scrutiny and therefore found it compatible with the First Amendment. The 11th Circuit, on the other hand, compared platforms to publishers. It argued that they are similar to newspapers because they perform editorial control of the content they host, and that they therefore should be allowed to exercise editorial discretion. And it subjected the Florida law to strict scrutiny, which led to a finding of breach of the First Amendment. However, these analogies have limits. So on the one hand, arguing that platforms are similar to common carriers, to telecommunication operators, seems misleading because, first of all, platforms make content-based decisions, which telecommunication companies don't. If you speak on the phone, no one is going to control the content of your speech, or at least we hope so. Online platforms benefit of immunities from responsibility, for example, in the US under Section 230 of the Communications Decency Act, and they are actually treated differently in the Telecommunications Act 1996. At the same time, the analogy with publishers is also not quite correct. Online platforms do not curate content, do not select content. They simply host the content that is put up by their users. They also do not assume responsibility for all the content they host. And in fact, this would be quite impossible because of the great disparity in the scale of the content. So just to give a picture, the New York Times publish about 150 articles per day, while Facebook users upload more than 1 billion stories per day and more than 100 billion post more than 100 billion messages per day. So it is a totally different scale of content that exists on online platforms. We will now zoom into one specific provision of the Florida law, which seeks to prevent censorship of journalism by online platforms. So the Florida law is stating there that a social media platform may not take any action to censor, deplatform, or shadow ban a journalistic enterprise based on the content of its publication or broadcast. And journalistic enterprise is defined by quite arithmetic, quantitative criteria in the Florida law, namely on the basis of it has to publish more than 100,000 words online, to have more than 50,000 paid subscribers, more than 100,000 active users, or to produce more than 100 hours of video, etc. So this is the way a journalistic enterprise is defined. Now, a similar attempt to protect journalism from censorship or moderation by online platforms is made in the UK Online Safety Act, where there is a layered system of protection. First of all, the websites of news publishers, let's say the BBC website, and the comments that are posted by users are completely exempt from the scope of the Act. There is also strong protection for recognized news publishers that have a presence in social media platforms, So their presence is exempt, and they are entitled to advance notification should any social media platform attempt to restrict their content.
Irini, you have 5 more minutes left.
Excellent, thank you. There is also protection for journalistic content in general, but this protection is much weaker compared to that afforded to recognized news publishers. So it is in the form of, for example, fast-track complaint procedures, but they are not entitled to advance notification. So we have different steps, and this raises the question, what is a recognized news publisher, how to define them, how to distinguish them from other journalistic content. There has been an attempt to protect journalists from moderation by online platforms in other acts. For example, in the context of the EU Digital Services Act, this was discussed, but it actually never materialized. In the proposed European Media Freedom Act, there is a very controversial attempt to ring-fence journalism from online platforms, and this has met with a lot of resistance and a lot of debate as to its effects and the categories drawn. In the German Network Enforcement Act, again, this was intimated, but actually only was included, a protection was only included in the memorandum to the act. So what are the arguments for and against? Well, there are arguments for moderation by online platforms, namely that their ability to curate, moderate content amounts to protected speech by the platforms, that they should moderate because the boundaries of journalistic work are porous, and if you prevent platforms from moderating, this would cause risks for the fight against disinformation. But there are also arguments against moderation by platforms, namely that journalistic content is already under the editorial control of press publishers and broadcasters, and therefore an additional layer of moderation by platforms puts press freedom in jeopardy. So in conclusion, platforms are between a rock and a hard place. If they do moderate, they're accused of restricting press freedom. If they don't, they are accused of leaving the gates open to disinformation and hate speech. And drafting a sensible media exemption is a difficult exercise because it risks empowering either private platforms or the states to become the arbiters of what is a recognized and effectively self-regulated media product. So the Supreme Court judgment might bring some clarity into these questions. Therefore, we should watch this space because this judgment might change the way in which platforms moderate content and generally operate